Wait another minute or so.
Okay. I could put out my card. I can leave it out there. I brought a lot just in case.
All right. Okay, let's get started. It's 5 after almost. So thank you for coming to, yes. That's okay. All right, so thank you for coming this morning to our community series. This one is on estate planning, and we have some refreshments over there, some pastries and coffee and tea and stuff like that. If you can grab that, it looks like people have done that already. You're free to have that. For those who know the church, there's a bathroom over there on the corner. There's one upstairs also. This morning, I'm pleased to introduce for our guest speaker today, Hong Chu. He's an attorney here in San Francisco. And just a little bio, but I don't want to embarrass him or anything. But just a few words. He graduated from Cal Berkeley, and then he went to law school here in San Francisco. He graduated and passed the bar and was admitted in December of 2023. I mean, 2003. So 20 years ago, not last year. Okay? More than 20 years ago.
20 years.
He started working for the Legal Assistance for Seniors in Oakland for a couple of years, dealing with elder abuse, eviction, consumer debt collection, naturalization, citizenship, things of that nature. Then he opened his own office in 2006 here in San Francisco, and he has a practice in family law, juvenile law, estate planning, probate, administration, immigration, business transactions and formation. And he is a specialist, a legal specialist here in the state of California, State Bar with child welfare legal. He has a child welfare legal specialization with the State Bar. So anyway, without further ado, this is Hong.
Hi. Thank you, Paul. Hi. So the easiest way to remember my name is to sneeze. In case you forget, you just hot chew. Okay, so I actually grew up on 18 and Clement. So this is my community. For many years, I went to St. Ignatius High School, and then, so I'm very familiar. My grandparents live on 38 in Balboa. I'm here to talk about estate planning, and I don't know if you guys have a whole lot of questions. I'll be available here after the presentation. I'm just going to go through a whole lot of general information, but if you have specific questions, I'll hang out to answer those. And if you prefer, we can make an appointment where I can go in depth into whatever your situation might be, your personal information. I'd be happy to sit down with you for like a meeting and going over whatever your, I guess, ideas or desires are, or intentions are. So estate planning is often confused with the trust. The trust is not the estate plan. The trust is only one of the 4 major documents under the estate plan. So if you were thinking of it this way, it's an umbrella. The umbrella is the estate plan. And then underneath the umbrella is your trust, your will, your power of attorney, and your healthcare directives. The trust is the most important document, but it doesn't do everything. You kind of need all 4 of these documents to work together to cover your life from now until after you pass. So one document cannot do it all. Okay, but everybody seems to confuse the trust with the estate plan. It is the most important document. So what the trust does is avoid probate court, and that's really the main purpose of a trust. It also is intended to, transfer your money to whoever you want to give it to. I'll let him finish. Yeah. Oh. And just so you guys know, I speak Cantonese. I'll sing to you again. We don't want to go to probate court. Probate court is expensive and time consuming. It costs approximately 5% of your estate. That means 5% of everything you own in order to transfer everything you own to whoever you want to give it to. It takes 1 to 3 years. It's a waste of time. It's a big headache. I do probate administration. I do trust administration. Probate and trust administration is the back end. And then estate planning is really the front end. So I do both ends, and I'm able to, plan for the back end because I also do the back end, the administration part of it. The fastest probate case that I've ever done is 9 months. So you're waiting around 9 months in order, your children, your heirs are waiting around 9 months to receive your money. And then they have to pay 5% of everything you own for court costs, attorney fees. So the way it works is there's filing fees, publication fees, appraisal fees, and then the attorney fees. And then whoever is administering your estate also gets a fee. If you add it all together, it's approximately 5%, but every case is different. It might be less or more for your case. So, but I just use 5% just to be quick and easy about it. So it's 5% of your gross estate. So what does that mean? If you own a house that's worth $1 million, but your mortgage on your house is $400,000, what you're really giving to your heirs is $600,000. It's 5% on $1 million. So the judge in probate court has to administer the whole house and not the net equity in it, not 600,000, it's $1 million, right? So it's 5% on $1 million. And so if you had a trust, all you need, all your successor trustee needs is your death certificate in order to start transferring your estate to whoever you give it to, right? The death certificate takes about 2 weeks. So the moment your trustee has the death certificate, we can transfer from you to whoever you decide to give it to. So this is your money. You can do whatever you want with your money. So when you set up a trust, you kind of have to think about your trust purpose. So I always call it a trust purpose, and that is what you want to do with your money. Your trust purpose can be anything you want because it's your money. You can set conditions. So some of these conditions are to my son, unless he marries, Jessica, who I hate, right? So that is a valid condition. To my son when he turns 28. So the typical condition is the age for distribution to your son, right? So the age is pretty important. My advice is that, at 25, I still didn't know how to use money. I wasted, right? So at 28, I'm using money to make money. So I recommend 28 and above, but it's totally up to you. This is your money, your trust purpose, right? You can create a trust for my dog until my dog passes away. Take care of my dog. The only conditions that are not allowed is based on race, gender, sexual orientation. So to my son, unless he marries a Chinese person. So that condition is not valid. It's just ignored. And then your son would still get his gift, your distribution to your son. So those conditions based on race is invalid. It's not enforceable. So you just get rid of the condition, your son would still get whatever you want to give to him, okay? Trying to create your trust purpose, you're allowed to do, again, whatever you want. You can do, a lot of clients would say $10,000 to my friend, $10,000 to my siblings, $10,000 to my church, and then the remaining amount distribute it to my children in equal shares at the age of 25, 28, whatever you set it to be. If you set conditions that are really weird, the whole point of a trust is to not go to probate court. And if people don't understand your condition, it ends up right back in probate court because a judge would have to decide what your condition meant, right? So keep it simple, but again, you're allowed to do whatever you want with your money, set whatever conditions you like, give it to whoever you want. Now, the most important part of setting up a trust is your successor trustee, all right? So super, super important. You need to choose the right people. All right, because this is your money, you design your trust purpose. All of this is your design, right? You just tell me what your design is and I put it together, I write it up. So your successor trustee, there are two criteria that I always tell clients when you go to choose that person or co-trustee, two persons, whatever, is that your successor trustee won't steal from you, won't steal from your children. All right, number one, the number one reason why a trust ends up back in probate court is theft. Somebody stealing your money. The second criteria when you go to choose a successor trustee is someone that won't dilly-dally, won't delay, is able to hire a tax accountant, hire a lawyer, hire a realtor to fulfill your trust purpose. You know, it's someone that's capable of dealing with tenants or dealing with filing taxes for you, whatever you need to get done under your trust purpose, that person's capable of doing it and won't waste time. The second major reason why a trust ends up back in probate court is that your trustee wasted time, didn't take action, is sitting around, waiting around, doing nothing. All right, so those are the two criteria when you go to choose your trustee. Now, you can design your trust based on your personal information, based on what you know, right? So you say, well, I trust my son, but I don't trust him completely, right? So you can say, my son can be successor co-trustee with my brother, right? And they can act by agreement. So it's kind of like you can't trust one person. You can add a second person as co-trustee by agreement, or you can do first, second, and third, whatever you like. It's based on who you know and their personality, whether or not they will steal. Money does change people. You kind of have to think seriously when you go to choose your successor trustee. The great thing about, excuse me, all of this is that it's amendable, revocable. You can change it anytime. The reasons why people would change or make amendments to the trust or any of these documents is because of these reasons: a death, a marriage, a birth, and a severe incapacity. Okay, so these are typically the reasons why people make amendments. It's not because of changes in the law. Changes in the law doesn't happen that much. It just happens very incrementally. There's really not a major reason for changes in the law to make amendments to your trust. Another reason to make an amendment is that you won the lottery. And I'll get to that later. It's about taxes, right? If you win the lottery, we'll have a different conversation. So the threshold amount to go to probate court as of this year, 2024, is $184,500. If you have less than that, and it only applies to checking, savings, stocks, and houses, okay? You have less than that, you don't need to worry about setting up a trust. You don't need, your estate will not go through probate court. It's simply paperwork in order to collect all the money, right? So you don't need to worry about any of this if you have less than that. If you have more than that in checking, savings, stocks, and houses, then you should set up something. So trust is only one way to avoid probate court. There are other ways to avoid probate court, okay? The other way is to set up a payable on death beneficiary for your accounts, checking, savings, stocks. If your company that, or your bank that holds these accounts have a claim form, not a claim form, a beneficiary designation form. Every bank has their own form, by the way. There's no one form for all the banks. They have their own form they created. You sign it, you designate your son as the beneficiary and submit it for whatever bank accounts you have. That is a way to avoid probate court. The only difference between designating a beneficiary and the trust is that your beneficiary will take your money and have no obligation to use your money to pay expenses, your debts, or your taxes. It just becomes the beneficiary's money, okay? If you transfer it to the trust, then the successor trustee must use your money for your trust purpose. It doesn't just become the trustee's money, right? So the beneficiary would just take your money and just do whatever he or she wants with your money. It just becomes the beneficiary's money. The trustee must follow the trust purpose, pay your expenses, your funeral expenses, your debts, your taxes, and then distribute based on your trust purpose, okay? So I have clients that do both, right? They'll set up a trust for the house, and then all these other stuff, they'll do a beneficiary designation to different people, all right? And that's okay. You know, you're not required to just follow the trust. You can do whatever you think is necessary because it's your money. Just understand the difference between the two. Now, there's also a beneficiary designation for houses. It's called the transfer on death deed, TODD. You guys heard a little bit about this too? So I'll go into that later. I'm just going to finish this up. There's similar to a beneficiary designation for your accounts, the beneficiary under your house under a TODD is not required to use your house to fulfill any trust purpose, just becomes that person's house, okay? So 184,000, if you transfer the house, and I do this automatically, okay? I get your grant deed and information on your grant deed. I create a trust transfer deed, and I have you sign it, and I record the trust transfer deed for your houses. I transfer the house to the trust at the time that you sign your trust, same time. The bank accounts and the stock brokerage accounts, I cannot do that for you. You have to do it yourself. You will get a binder. The binder has a trust certificate. You have to bring the binder down to the bank, probably talk to the branch manager and say, hey, this checking account or this savings account, I want you to transfer it to your trust. You get to name your trust, whatever you want to name your trust, okay? The bank would simply, they'd simply change the name of your bank account. The account number stays the same. The money is the same. It's just that the name is, instead of Hong Chu, it's Hong Chu Trust. And so the very next monthly statement from the bank has your trust name on it. All the money in that account now falls under your trust and must follow your trust purpose, okay? So when you set up your trust, you're the initial trustee, and you're the beneficiary of the trust, and you're the principal of the trust. So until you pass, nobody has authority over your money, just you. That's why it's revocable, it's amendable, and you can take it all back if you like, okay? A typical reason to revoke a trust is if a married couple became divorced. You cannot have a joint trust if you are divorced. So you would have to create separate trusts, one for the divorced husband and one for the divorced wife if you divorce, right? So you just revoke your trust. You're not allowed to have a joint trust if you are not married. So any questions so far? I'm forgetting something here. Yes.
For the accounts that already have beneficiaries, you transfer a trust and you recruit beneficiaries?
Yes. Yes. Actually, you just transfer it to the trust and it's all under the trust. But yeah, you tell the bank and then, yeah, you should revoke the beneficiary. It's kind of up to you how you want to set it up. As long as you don't end up in probate court with this expense and this time and this frustration, it's really, really a big burden, okay? And people are waiting around for nothing. So avoid probate court if you can. And it's really private. Like this is just between, there's no such thing as a trust police. You can't call 911 if your trustee is stealing from the beneficiary, okay? The way to enforce the trust is that the beneficiary has to sue the trustee, okay? So if your trustee, you chose the wrong person, beneficiary sue the trustee, guess what? You're back in probate court, all right? The whole point of this is to avoid probate court. So plan wisely, choose the right people that won't steal is the biggest problem. Okay. Yes. Okay, good question. So those accounts, you're supposed to designate a beneficiary already, right? And they will not allow you to transfer a 401k or an IRA to your trust. You can designate the trust as the beneficiary, right? Or you can designate your children as the beneficiary. Now, for any retirement account and you're married, you should always designate your spouse as the beneficiary because they continue your tax exemption, your tax deferment under the same retirement account. So always designate your spouse first for retirement accounts, right? And then you could do a secondary beneficiary. It could be the trust, or it could just be your children. You can skip the trust if, for hypothetically, if your trust gives everything to your children anyways, you're kind of creating an extra step by designating the trust as a beneficiary when you could just designate your children, right? So you're going to the trust and then it goes to the children. It's kind of silly, right? Just go straight to the children. But if your trust says, $20,000 to this church, 10,000 to my relative, all this cash needs to be fulfilled, you can designate the trust as a beneficiary under the 401k as a secondary, or any other, like a life insurance, you can designate the trust because it needs to have cash to fulfill your trust purpose, because your trust purpose is, 10,000 here, 10,000 there, and then the rest give it to my children. So it depends on what your trust purpose is. So if your trust purpose has a lot of cash gifts to people, it needs cash. Otherwise, your trustee will need to sell your house to fulfill these cash gifts, right? So it's kind of up to you how you want to plan that out. Just remember that, so part of the rule for trust administration, just so for your information, a beneficiary is only entitled to cash unless you say in the trust declaration that this person gets the house or this person gets the car, right? If you don't say that, they are entitled to cash only. And it's up to your trustee to decide what to give your beneficiary, right? So if hypothetically, the beneficiary tells the trustee, I want that car. Okay, and then the trustee says, no, I'm going to keep the car. You get cash. Guess what? The beneficiary has no authority to ask for the car. It's up to the trustee. So the trustee has a lot of power and a lot of discretion here, right? So let's say hypothetically, you have 3 houses and, between the 3 houses, one of them wants the house that has rental units, all right? The beneficiary wants the house with rental units. The trustee says, no, you're entitled to cash and we're going to sell everything and give you your share. Okay, so the trustee has a lot of power. There's a way to offset. So let's say hypothetically, the trustee says, okay, you can have the car. We're going to offset the fair market value of the car from your share. All right, so whatever the fair market value, take off, $20,000 from his equal share of whatever. So you add up your entire estate, you have a grand total, divide that by 3. The trustee is allowed to keep a reserve. The reserve is for taxes, expenses, and debts. All right, and then you divide the 3. If the reserve amount is not used, you can eventually distribute it. There's this 3-year statute of limitations for debts after you die. All right, so the trustee, I typically ask the trustee, well, what do you know about the principal? Does he gamble a lot? Does he owe a lot of people money? Because if he does, let's keep a bigger reserve and hold on to that reserve for at least 3 years, because that's the statute of limitations for people to recover a debt. All right. So, you don't want someone coming out from the woodwork saying, hey, your father owed me, $80,000 from 30 years ago. Here's the note. You know what I mean? So who knows, right? But your trustee has a lot of power here. He or she can decide. And, if you don't like one person, you could do co-trustees. So a good example is my client would have 2 children. My client says both children will be co-trustee and they have to act by agreement only. So they have to basically negotiate with each other about which asset they want based on the grand total. You do an appraisal of both houses, grand total, divide that by 2, and then just say, hey, this house is worth less than my share. I want that house, offset it, et cetera. So this is a whole nother area of law. It's the trust administration part of it. It's not the estate planning. But if you know about the estate trust administration in advance, you can plan for it at the front part of it, okay? So the basic part of this is just whatever you want to do with your money, you can do it. Just don't go to probate court, is your point, right? So set it up. Or do beneficiaries if you like. So here's the will. Excuse me. The will is a catch-all. So let's say my hypothetical is you win the lottery and then you pass away the next day. Okay? It's some luck, right? Your lottery winning is greater than $184,500. Your lottery winning will have to go to probate court. Oh, thank you so much. And your lottery winning will still have to pay 5% for the probate court case. And still take 1 to 3 years to finish. So, but your will, it tells the judge in probate court, give everything that I forgot to transfer to my trust, give it to my trustee and follow my trust purpose. So it just catches everything that you forgot to transfer. Let's say you had an accidental death and your checking and savings did not have beneficiaries. It's greater than $184,500. You still got to go through probate court, do all this, but it will be transferred to your trustee to follow your trust purpose. It's just a catch-all. Okay, so I transfer your houses right away, but the bank accounts, I cannot do that for you. They'll arrest me, right? I can't go into your bank and try to change your account. I do remain your attorney for these documents. So if the bank has an issue with the trust certificate, I would fix it. Okay, but typically banks know trust all day, all the time, et cetera. And then they can transfer the account, but it's kind of up to you when to do it. You don't need to do it right away if you don't have an account greater than 184,000, right? If you don't have money like that, or if you have, you have several accounts, and one account has 300,000 just collecting interest. Then for that account, I would tell you go ahead and transfer it to your trust. If you were sick and dying, then I would say don't worry about the amount in the accounts. Just transfer everything to your trust. Okay, so, but if you forgot or you didn't do it in time, guess what? The will will catch it all and transfer it all to your trustee to follow your trust purpose. Okay, that's all that it does. Power of attorney. This one is the best. I love power of attorney. All right. This is your life inside the circle. Inside your life is a box called the trust. Okay. You have a house. I immediately transfer the house to your trust. Okay. But outside of the box, but in the circle, you have your checking account, your savings account, your stocks. You have your 401k, your IRA, your life insurance, your health insurance, and taxes, Social Security benefits, lawsuits. Okay. So you need to choose an agent. This is what I call the money person, all right? Same two criteria when you go to choose your agent, okay? Someone that won't steal from you, right? And someone that can take action, like hire a tax accountant, hire a lawyer, and do things for you, okay? Same two criteria as your successor trustee. The only difference between the power of attorney and your trust is that your power of attorney comes alive when you're incapacitated, right? So the example that I use is if you get in a car accident, somebody hit you in a car accident, you're in the hospital, and the doctor in the hospital says, hey, you can't leave the hospital. You're going to take 2 months to recover. So for those 2 months, you still have business to take care of. Your agent would take this document out of the binder that I create for you. And let's say hypothetically, your health insurance stops paying the hospital bill, right? You're in the hospital because of that car accident. Your health insurance stops paying the hospital bill. You need someone to deal with that. Your agent will pull this document out, send it to the health insurance company, and suddenly your agent has the authority, as if your agent was you, to do everything that you can do and say, hey, why did you stop paying the hospital bill? You need to pay the hospital bill. This document has the health insurance company, gives the health insurance company authority to talk to your agent, and then your agent can do basically anything that you can do, your agent can do. Okay? This document is invalid on the date of death and after. All right? So everything after the date of death, let's say your agent tries to do something, it just becomes invalidated and reverts back. if he or she did something after your passing. Okay, so hypothetically, your car accident was really terrible. The doctor says, hey, you really got 2 months left to live. Okay, so your agent, I hope, would call someone like me, and I would tell your agent, okay, transfer all the checking, savings, and stocks to the trust. Use this document and this document. Go to his bank or her bank. Transfer the checking account to your trust. Okay, so your agent will hopefully do that. Double check the beneficiaries for your 401k, your IRA, your life insurance, right? Just make sure that the beneficiary is still alive and it's valid. That way it avoids probate court. If your beneficiary is passed under your 401k or your IRA or your life insurance, and there's no other beneficiary, guess what? It goes through probate court. It goes through probate court. It fails because your beneficiary has passed before you, and you didn't take the time to add a new beneficiary. So all those accounts that go through probate court, it's catch all. The will catches it and transfers it right back to your trust. Okay. Your agent can file a lawsuit as if you're the one suing the person that hit you in the car accident. All right. So you're in the hospital. Your agent can file taxes for you, can apply for Social Security benefits for you, can apply for disability benefits for you, and sue the person that hit you in the car accident. Okay, so your agent can do anything that you can do as if the agent was you. And again, those two criteria are very important. It can be the same people, by the way. So your successor trustee can be the same person as the agent. So the way I like to describe this is I'm Hong, right? But I wear different hats. So it depends on what I'm doing. If I'm dealing with something under the trust, I'm wearing my trustee hat. If I'm dealing with something outside of this box, this is a trust, and I'm dealing with something other item or some other asset outside of the trust, I'm wearing my power of attorney hat, but I'm the same person. Okay. If you don't trust one person, you can do co-agents that act by agreement, or first, second, and third. Whatever you design this estate plan to be, you need to kind of think about your people, right? Who do you trust? If you don't have anybody to choose, that's a big problem, just so you know. But hopefully you'll have plenty of people to choose from. The main thing is that they don't steal from you. The healthcare directive, same thing. You choose an agent. For a husband and wife, it's typically your spouse, right? But you need a backup agent in case your spouse passed, right? So who is your backup agent? Between the husband and wife, the backup agent is typically some relative from the husband's side for the husband and a relative from the wife's side for the wife, right? You probably won't choose someone from your in-law to be your agent. So the healthcare agent, your agent will decide things like surgery, letting you pass, or saving your life, putting you on a machine, putting you in a nursing home because you lost your memory, okay? Or keeping you at home and taking care of you at home. Your agent can decide these things. So between the power of attorney and the healthcare directive, because it's your design, you can tell me, I want these documents effective immediately and not when I'm incapacitated. So let's say hypothetically, I have a client that's 85 years old and can't really get out of the house, right? So he'll tell me, I want these two documents. I want my agents to have authority immediately. I don't need to wait till I'm incapacitated. And you can do that. It's completely your design. So with the healthcare directive, you can design it by saying, I want my agent not to have authority to make a decision if I'm in a coma. If I'm in a coma, just let me pass. I write it into this document. Agent has no authority. I don't recommend that. I don't recommend that. Do not do that. Okay? The reason is that you're sort of committing suicide on paper, right? Why is that? Because there's a million different diseases that can affect you. Who knows what might affect you, right? And there's a million different cures and treatments. And you're going to live another 20, 30, 40 years. There's advancements in medicine every day. And there may be a cure for you for your specific condition of the million different diseases that affect you. For your specific condition, there may be a cure. But you're in a coma and you said, hey, let me die, right? So I recommend that you give authority to your agent to talk to doctors about current medicine that can save your life at that time, because you're going to go another 20 years And at that time, there may be medicine to cure you, but you're in a coma and you wrote in here, hey, let me pass. So I don't recommend that. So the agent should talk to doctors about current medicine that might, address one of the million diseases that can affect you, right? And probably talk to family and friends before making decisions. Okay, so I recommend that you let the agent decide. It's just a matter of choosing the right person that knows what you want, okay? Is able to talk to doctors about cures and treatments and medicine that affect your condition, okay? Because there's a million different diseases, who knows what might you get and what cures and treatments there are available. So don't commit suicide on paper. Okay. Those are the four. Oh, by the way, let's talk about taxes, and then I have to kind of tell you something about this. Okay, so for the trust for married couples, the default rule is that when one of you pass, 50% of the trust estate is locked up. The surviving spouse cannot change that 50%, right? Because if I pass away and I wanted my money to go to these people, my wife who survives me cannot change that. She can change her 50%. And this is just California law under community property, right? You can opt out of that. That's just the default rule. We can write out of that through your trust declaration. You can say, I trust my spouse completely. If I were to pass away, I want to give the surviving spouse full authority to amend and revoke 100% of the trust estate. Okay, so it's kind of up to you. So if you don't tell me that that's what you want, we go with the default rule, which is 50% is locked up. Okay, it means that the surviving spouse can still use the money, but cannot get rid of the principal that is 50%, because that principal 50% is intended for the beneficiaries that the deceased spouse wanted to give to. Okay, and then her 50% or his 50%, that's the surviving spouse can do. She can do. The example is your surviving spouse remarries and marries a 22-year-old. And is in love with this 22-year-old and decides that she or he wants to give 100% to your new spouse. Or it gets tricked by that. Who knows? But if you trust your spouse not to do something like that and will give it to your children, then you can say, hey, Mr. Chu, you can give 100% authority to the surviving spouse to make amendments, etc. Who knows what will happen in the next 20 years after you pass, right? There may be a need to do something. I don't know. And I've actually seen this happen a few times, just so you know. If you go by the default, which is 50% is locked up and the surviving spouse really needs to do something to take 100%, you need all the beneficiaries of that 50% to sign off. Okay, that's how you make an amendment to the 100%. So let's say hypothetically, I pass away, my kids are my beneficiary and they talk to their mother is sick and needs all the money. I don't know, whatever the reason. Or the mother wants to make an amendment. The mother would need my kid's signature as a consent for the full amendment of the 100% or my 50% because I passed. Okay, so that's something, it becomes a sensitive topic with married couples, just so you know. But just think of that. And the reason why I say that is because of taxes. So we're going to go into taxes now, okay? Any questions so far before I go into taxes? Okay, so there's 3 taxes that you have to know. And they are apples, orange, and pears. You do not mix the two. They are not analyzed together. You do not analyze taxes together, okay? If you're talking about one tax, do not talk about the other tax. They don't go together, okay? The first tax is called the death tax or the estate tax. As of this year, 2024, the estate tax exemption amount is 13.61 million per person. Okay. If you're married, it's double that, 27.22. million. So it's tax-free up to that amount. And between husband and wife, you could use the whole 27 million after one person passed. Right? So let's say your spouse passed and you didn't claim any, the surviving spouse can take 27 million tax-free if you're worth that much. By the way, if you are worth that much, we're going to have a different conversation. Okay? It's not going to be this conversation. And in fact, I would probably refer you out to a tax lawyer because there are many, many strategies to avoid taxes. That's more than just setting up a trust. Setting up a trust is easy, right? You just give to my children, fulfill my trust purpose, right? But for tax strategies, if you're worth that much, anything above this amount for one person or above this amount for two person is 40%. Okay, so hypothetically, if you have 14.61 million, the last million that's over 13.61 is tax that your children would have to pay 400,000 to take the remaining 600,000 of the extra million above 13.61 or whatever the amount might be. Okay, so that is the estate tax. There's really not much to talk about. Don't worry about it. In the past, it used to be like $1 million, which is nothing compared to now. Okay, so in the past, they had all these strategies under a trust declaration. They call it the ABC trust or the AB trust and the ABC trust. We don't do that anymore. It's not necessary if your net worth is not that much. Okay, the capital gains tax. Who knows about capital gains? So the easiest way to kind of think about it is if I buy an Apple stock for $5 and I sold it for $100, okay, let's do the $5 Apple stock, right? And now it's $100. You sold it for $100. You made $95, right? And that's taxable at 15 to 20%, depending on your income bracket. Okay, and it's taxed at the tax year that you realized the $95. So if you sold it in 2024, the tax on the $95 is due April 15, 2025. You need to report it as income. Okay, same thing with houses. So let's say you bought a house for $100,000. Let's say 30 years ago, you bought a house for $100,000. And then this year, it's worth $1 million. Okay, and if you sold it this year, let's say 30 years ago was 1993, and then 1994, 2024, and it's $1 million. If you sold it in 2024, you made $900,000. Okay, at $900,000, you're paying 15 to 20% on that because that's something that this is considered capital gains income. Okay, you made money. All right. 15 to 20%, depending on your tax bracket, unless there's exemptions, right? If it's your personal residence, you get an exemption of $250,000 off per person between married couples only, okay? So if you're married and you're both on title, then you could take $500,000 off, right? So you'll be taxed at $400,000 at 15 to 20%. Does that make sense so far? Okay, so the way to take advantage of the exemption under capital gains, there's no way to cheat it. You got to die. You need a death certificate. Okay, so if you die and have a death certificate and then you give your house to your children or give your Apple stocks to your children, they take the fair market value on your date of death for the house or for the Apple stock. So they take it at $1 million if you pass away this year, and that is their starting point now instead of 100,000. Okay, so you just created a brand new cost basis is what we call it. I like to call it a starting point for calculating capital gains tax, right? The very worst thing that you can absolutely do, okay, do not do this. Don't do this. Do not add your children onto your title to your house. If you add your children onto title to your house, they have to take on your starting point for calculating capital gains tax. Okay? So a lot of people make this mistake. They add their children onto title as joint tenants. So that way I don't have to do a trust. All right? If I die, it would just automatically go to my children without going to probate court. Right? But you avoid probate court. That's great. But you got to pay this tax when your children finally sell the house. And their starting point is your starting point, the purchase price, plus any improvements. This is the worst thing you can absolutely do. Do not add your children. Wait till you pass and then give it to your children. It does not matter if you have a trust or you went through probate court. This is a federal tax. It applies regardless of whether or not you have a trust. Okay? So if your house had to go through probate court, your children would still take the house at the fair market value on your date of death. So the reason why we always do an appraisal of your house after you pass, okay, this is trust administration now, right? Is that the appraisal forms the basis for an audit by IRS. If they audit you because they think that your cost basis is here rather than the fair market value on the date of death. So the hypothetical is your children wait until, let's say 2028 and sells the house at 1.5 million. How's that? 1.5 million. And then your children get an audit from IRS and say, hey, you owe capital gains tax from 100,000 to 1.5 million, right? And you say, no, I got it from my parents' death. Here's the death certificate, and here's the appraisal based on the date of death, which is here. And then so the gain is only 500,000 instead of 1.4 million. And they would pay the tax on 500,000 here. Okay, so it requires a death. There's no way to cheat this tax. Okay, you need a death certificate to get a step up in cost basis. I call it a step up starting point. The new starting point is here, date of death. Okay, any questions? The third tax is property tax. This is the absolute worst thing in the world. I hate it. All right, Prop 19. I don't know how it got passed. So what's Prop 19? Prop 19 allows you to transfer the property tax that you have now to a brand new home, even if the new home is more expensive. Only if you're 55 years old and older. So let's say you're retired and you want to move from San Francisco to Hillsborough. Okay, you buy a really expensive house in Hillsborough, you can transfer the property tax that you're paying now to your new house. And so you'll still pay the really low property tax. But when this law passed, they put onto the tailgates, they added onto this law that says that if you die, you cannot get the tax exemption on property taxes. They will be reassessed for every property except your personal residence, and only if, so this is property tax, okay? This is not capital gains. Property tax. You get $1 million exempt if the house is your personal residence and your child makes it his or her personal residence. Okay, that's the only house that gets a $1 million exemption. So let's say you live in the Richmond district and you have a house that's worth 1.4 million when you died. Okay, this is your personal residence, and then your son moves in. Okay, he gets the first $1 million exempt. That means he's going to pay the property tax that you've been paying. Okay, the same property tax that you pay, he's going to continue to pay that plus 1.15% on 400,000, which is above $1 million. So that's about $4,000 probably, right? So you add $4,000 on top of whatever you've been paying for your property tax. That's what your child would have to pay for the new property tax if he moves in. If there's an audit, they have to check your PG&E bill, your water bill, does it have your son's name on it, et cetera, blah, blah, blah. You have to file a homeowner's exemption on the property. I do all of that, by the way. So whoever is your successor trustee is They just have to find me. They sign and pay, and I do everything. I file all the forms, et cetera, and then transfer title based on whatever the trustee decides. That's the new property tax. Everything else, second property and investment property, is going to be reassessed at the fair market value on the date of death at 1.15%. Okay? This is a terrible law. We're trying to reverse it now. Okay, go ahead. No. No. They have 1 year to move in. You continue with that property tax. Yeah, there's no law says when you move out. So you could do that. You're right. Yes. Right. Yes. It's already been reassessed. Sure. So if you had two houses that you left to your children, so the house that your child moves into has to be your residence. That's the only one that counts. It cannot be the second property. Yeah, you can only have one residence, right? So you can't say I live in two houses, right? You're gonna. So whoever your child is has to. It can only be a child. It cannot be a relative. Cannot be anybody else. Your kid needs to move into your home and make it his home or her home in order to take the $1 million off of reassessment. Okay. The second house is already reassessed at the new tax because it's based on your date of death, right? They have 3 years to do the reassessment, but by the time they finish the reassessment, it's retroactive to the date of death. So, you're already paying the new tax by then. You can't move into that second home. So her question is, what if the child moves from the primary residence to the other home? It doesn't count. It's already been reassessed based on your date of death. Okay, and it has to be your personal residence. Yes. Yes, it does. Yeah, but the grandchild has to move into the grandparent's house. And you're skipping the parent. So if you're planning it that way, great. But, who knows? Maybe your child is already wealthy, so you want to benefit your grandchildren. Yes. It has to be your personal residence. So this is a brand new, I mean, technically you can say that your spouse lives in this house and you're in that house and you're giving to different kids. I don't know. This is a brand new law. It was passed 2021. All right. And so I don't practice you can contest a reassessment of your property tax, right? You can challenge it. I just don't do that. That's not a field that I'm well aware of. And I don't know all the different challenges to Prop 19 in this tax, but we're trying to reverse it. It'd be better if we reverse it. It used to be all your property does not get reassessed, up to $1 million though. And it's right. 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 And again, I don't do the reassessment challenges. All I know is that it has to be your residence. So where you live and then your kid moves in. Yes. You need to move in within 1 year. It doesn't say how long, it doesn't say. But we know that reassessment can take up to 3 years. So you want to wait till you got it before you move. Right? And you have to file all these paperwork, the claim of exclusion between parent-child transfer. I do all the forms and I file for you, just sign and pay. Okay, those are the three taxes. Do not talk about them together. They're totally apples, orange, and pears, right? You cannot say, oh, well, you're saving on this tax. You just got to analyze each independently, okay? So the reason why I talked about, well, I'll skip that. I think that is pretty much it for my presentation. You guys have any specific questions about estate planning? So the only real, if they're receiving your stocks and your houses on your death, they get a step up in cost basis. There is no tax. Yes. It's supposed to be your estate, and whoever, if you have a trust, then obviously your trustee is going to cover that. Yes. 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 You're talking about your specific own income for the year that you pass away, right? It would be whoever the creditor would sue, either the trust or the probate case, or sue the person that took the beneficiary, right? So the creditor has to come forward and bring a lawsuit. So there is a creditor period, waiting period. It's 4 months from the date that a personal representative has been appointed by a judge. So you have 4 months for the creditor. There's publication, of course, right? So you publish, and if you're a creditor, you're supposed to have notice from the publication to bring your debts to the personal rep. And I would assume that if there is no probate estate, the creditor either sues the beneficiary under the TODD. The taxes. So I will tell you that I'm not a tax lawyer. And for these tax questions, you probably need to speak to a tax accountant or a tax lawyer. The estate planning of it, I do. I think that your question deals with there's income tax for the tax year that you die, right? And that has to be paid by somebody. Typically, it's your estate, right? And you're saying that if all the money in your checking accounts go directly to the beneficiary under the payable on death, I don't know. I don't have the answer to that. It's going to be, I assume that there's withholdings under your income, your pay, and those withholding is going to be applied. If there is an estate, right, there's a lot of money greater than $184,500, someone's going to open the estate, and that's where the tax is going to be paid. Because in order to close the estate, the judge is going to ask, did you pay the taxes? Right? If you have less than $184,500 and you only have income tax that you owe, I don't know if the IRS is going to come after you, to be honest, or after your beneficiaries.
So your question, Alan, I'm an attorney too.
Oh.
So I don't know the specific answer, but I think your idea is that you run up a lot of debt. Say if you run up a lot of debt and then you just give your money away on these TDODs, I think that's considered fraud. So you're going to get your estate or the beneficiary is going to get sued for fraud. It's not a true transfer. Well, it is a true transfer, but it's to avoid debt. It's fraud. So I'm pretty sure that some enterprising attorney will sue whoever has the money. And I work for the government, so we always sue people. We never not get money. Because our budget's contingent on getting money. So my job is to get money.
Are you the city attorney or no?
I was state California.
Oh, awesome.
All right. So
go ahead.
This is regarding income tax on investment accounts inside the trust, but the capital gains and dividends, do you report those to your personal income tax, or you have to do another separate tax?
So the trust is considered disregarded, right? While you're alive, your trust is invisible for tax purposes. You report under your Social Security number as if the trust doesn't exist. It's considered disregarded, okay, until you pass away. And if you pass away and your trust must go longer than the year that you pass away, your trustee needs to get a tax ID number for the trust entity and then report all those incomes, right? But while you're alive and you're the principal of the trust, it's disregarded. You just report all your income as if you're doing it as if the trust doesn't exist, right? It comes alive when you die. Yes. Yes, I haven't talked about that. Do you want me? Let's go into that, okay? Transfer on death deed. It's adding a beneficiary to your house. You got to record it. It requires 2 witnesses and a notary. If you're a single person at property owner, it works great. You don't need a trust. It just goes to your beneficiary. Okay. If you're married, then it becomes a little bit of a problem. Okay. Each person, co-owner, has to do their own TODD. Okay. And designate beneficiaries, right? But whoever passed away first, the surviving spouse become 100% owner. You don't have a trust, so it's not locked up. The 50% is not locked up, okay? The surviving spouse become 100% owner, and guess what? The surviving spouse can change the TODD beneficiary, can sell the house, and the TODD doesn't apply anymore. Right, right. It's an alternative to avoid probate court by not doing a trust. You just simply designate a beneficiary for the house, right? Kind of like designating a beneficiary for your bank account. The lawmakers created this TODD to save people money from setting up their own trust. It's really, that's it. You know, you could do it. It's a form. You go in front of a notary, have a couple witnesses, designate your beneficiary, and you totally don't need a trust. But again, there's no trust purpose now, okay? The house just goes to your beneficiary. If you're a co-owner, though, there's a problem. The surviving co-owner takes the whole house first, unless you create a tenancy in common ownership, right? So if you do a tenancy in common, so let's talk about that. I absolutely change, if you're husband and wife and you own property as joint tenants, I change it to community property first before I transfer it to your trust. And the reason is that for joint tenants, you can own a house with 4 of your siblings, right? And if you're owning the house 4 siblings, joint tenants, each joint tenant has to have exactly the same share, okay? So it's 1/5, 1/5, 1/5, 1/5. And if one of them pass away, you get a step up in cost basis for capital gains tax only on 1/5, okay? If you're husband and wife, why on earth would you want to do that? Right? If you're a joint tenant, you're exactly 50-50, exactly. So if one of you were to pass, you only get a step up of 50% on capital gains. Because you're husband and wife, and as long as you're husband and wife and you change title to community property, guess what? 2 people become 1 person. Each of you own 100%. So if one of you were to pass away, you get a step up of 100%. So the surviving spouse would have no capital gains tax. Okay? So we want to change your deed if you're husband and wife from joint tenants to community property. It costs $30 to record that deed. It really isn't a big deal. You should do it because you get 100% step up instead of a joint tenancy, which is only 50%. And if the surviving spouse get a full step up on the house, you can sell the house without having to pay any capital gains tax. Okay, so I always do that. Must. It saves you a ton of money unless you have some crazy reason. Like, I don't know. Your own personal reason. Oh, TODD. Yes. Unless you have some weird reason. You're not married to your brother. So you have to be married. Only married couples. Right? Only married couples can take advantage of that. Right? And the siblings, no. Right? You don't get a 100% step up. Just 50, whatever the equal share of each joint tenant. So TODD is really simple. Fill out the form, record it, notarize it, and then you have a beneficiary. For a single property owner, it's easy, right? It works. It does avoid probate court. But for co-owners, it just becomes a big problem. The surviving co-owner can make all kinds of changes, and your TODD beneficiary may not get it. Okay? And there's no trust purpose, fulfilling your trust purpose like expenses, liabilities, taxes, and then pay $10,000 here, $10,000 there, the rest to my children. You know, if you have that kind of trust purpose, the TODD is not what you want. It just goes to the beneficiary.
They get 1 million from the state, right? So whatever the assessment, that 1 million will be
Exempt.
exempt.
Right,
So whatever value, let's say it's worth 2 million.
right,
So then that only 1 million, 1.5
right, percent.
is going to be their property tax.
No, whatever you've been paying as your property tax plus, right,
Plus that million.
right,
At 1.5, your property tax.
correct,
Yeah, figure out how much they can.
right, yes, and it's,
So they have to pay that every year to pay occupy it in any year with that.
yes.
And how long do you-
I don't have the answer to that, but the reassessment period is 3 years. They have, the county has up to 3 years to reassess your property and it will be applied retroactively. Right, right. 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 I just hate to say that because if they haven't finished the reassessment and you moved out already, they might revert back. That's why I don't like to say 2 years. Yes, you're right, though. I typically do say 2 years for residents, but if they haven't finished the reassessment, I would stay put, you know. So you're mixing taxes now. Step up is capital gains, property tax is Prop 19. Sorry. They can, they just have to make it their residence now and forget their own residence. They need to show that they moved into your home, right? And there's something called a homeowner exemption form. So it depends on when you file that, which property you're filing that form on. You need to file it on your parents' property that you moved into to qualify for the Prop 19 exclusion, right? And then, you know, if they audit you, you need to show, you know, utility bills, blah, blah, blah. And again, you're right, it is 2 years for residents, but if they haven't finished the reassessment, I won't move, right? So anyways, you know, they have up to 3 years to do the reassessment. That's why I don't like to say 2 years, because if you move and they haven't done it yet, well, they might change their mind. I don't know. Okay. Let's see. I've been an attorney for 20 years. I've been doing estate planning for 17 years. I probably served over 400 families, more or less. My fee does include future amendments. So if you came back to me 10 years later, 15 years later, and I'm still practicing, I'll do your amendments. It's already been paid for. Again, typically it's for death, birth, marriage, or severe incapacity. Okay, for an amendment. It's easy for me if I establish your trust to make an amendment for you. It takes me, you know, 5-10 minutes. Let's see. I think that's it. Yes.
So my question to the tax, so like, for example, I have a family tax and I have house. There's one of person, like a couple, one of person. The house going to get stepped up 50%?
100% if you change title to community property.
Oh, so you mean,
It's only between husband and wife.
okay, like, right now, if the house is under the trust, so what, if one person pass away, so your suggestion is going to change the house back to community property?
No, regardless of whether or not you have a trust, the capital gains tax is a federal tax. It applies even if you don't have a trust.
No, but I mean, it's like the house already put in,
The trust, right. So before I transfer your house to the trust, I change title from joint tenancy to community property first. And then I transfer it to your trust. Because we want to take advantage of the step up between husband and wife and not just 50%, 100%. And once it's community property, we know that you're husband and wife now. Because a joint tenant, you could be a joint tenant with anybody. But we want to say you're husband and wife to take advantage of the capital gains step up for between husband and wife. And then you transfer it to your trust. The step up happens even if it's in your trust.
Oh, okay, so you mean it also look back to the title you holding?
Yes, 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 absolutely. That's between husband and wife, yes. That just means that if you don't have a trust, it just goes to your spouse after the first spouse to pass. Yeah, but you're absolutely right. But after one spouse passed and the surviving spouse owned the house, it doesn't go into anybody else except probate court if you don't say it like a TODD or a trust, right? Does that make sense? You're not planning for who's going to receive from you.
I think your question is, do you want to summarize what her question was?
So her question is, how do we get this? Why do we get a step up if we transfer it to the trust? The answer is make title as husband and wife first as community property in order to say that you are husband and wife before transferring it to the trust. The step up doesn't apply until you actually sell the property and realize the money. Okay, so if you never sell the property, you don't take advantage of the step up, right? It doesn't matter. The step up is hypothetically when you do sell the property after one spouse passed and there's an audit by the IRS. Well, you say, well, it was community property. Look at the title. Okay, we transfer the trust after changing it to husband and wife, and my spouse passed. And here's the date of death. Here's the value of the property on the date of death. And then you realize money when you sell, right? That is cash now. And that's when you say, hey, there's capital gains, you have to report it. Then when you go to report it, you tell IRS during an audit that you have the step up, or you report it by saying that the starting point is the fair market value on your spouse's death, right? And then say, hey, this is how much money I made, capital gains, and it's due April 15, the year after you realize that money. Okay, it's locked up in the house now, you don't realize it, right? When you sell it, you do realize it's in your bank account now, and that's when it's reportable and taxable, and you have to pay. Yes? You just put it into the trust, it goes to whoever you want to give it to. That is your trust purpose. It's completely your design. You can do that if you like.
But it's all going to get reassessed to present day value, like we got 20 years ago. Because the taxes are going to get reassessed when I die, right?
Which tax? Property tax? Yes. Yes. Capital gains tax? No. Right. You're talking different taxes together again. So I wouldn't, they're apples, oranges, and pears. So you just.
Property tax would be reassessed.
Yes.
The capital gain.
Oh, you get a step up to the date of death until you finally sell. That's your starting point for calculating capital gains tax. Capital gains tax? No. Fair market value on the date of death is your new starting point for your heirs, for your beneficiaries. You're just mixing taxes, and it confuses everything if you mix taxes. Just think of it independently. Yeah.
Earlier you mentioned the 1.15 million something.
Yes. The state tax. Yes. That's the exemption amount. It hasn't passed yet, so I don't know. I mean, we're hoping that it keeps going up and up and up, right? But our lawmakers, I don't know. The new law hasn't come out yet. It's going to keep going up unless our lawmakers in Washington, D.C. decide to change all that. Everybody's going to be really upset if they bring it down. right? If they bring it down, everyone's going to be really upset. So I don't know. But as of right now, 13.61 million per person exempt, double that if you're married. Yes. If you're married, yes, there is no reassessment between husband and wife. Absolutely not, right? It's just when your heirs finally receive it from both of your passing, there will be a reassessment. Yeah, husband and wife, you get all these, privileges and benefits by being married, so. Right. Right.
And then there's a third option for couples is gay property with rights of ownership. That would still suffice.
If you're not doing the trust, yeah. Yes. Yes, absolutely. Yes. Right. No, you get the full 27.22 million as a surviving spouse. Right. You can go all the way. It's called portability under the estate tax law. It just means that you can claim up to 27 million if you were married. Yeah.
All right.
Yes. Yes. Yes.
And how long typically does that take?
If I have complete information, I could turn it around in a week. And my fee includes amendments, right? But so I do things a little bit differently. I have you sign it, right? Because the essential intent, essential trust purpose is going to be there. Have you sign it, have it established because you need to establish it, and then slowly read it. And if you see anything wrong with it, I correct it. Because my fee includes amendment, it actually includes corrections too. So, but if you rather read it first before you sign it, that's no problem. It just takes a lot longer.
So can you explain a little bit about the process though before we get to that point?
Okay.
Like, we set up plan, we have
Right.
we know what's even put into the trust.
So my initial meeting with clients is free. There's no fee. This is where I do the whole presentation, explain everything, answer questions. And if you don't want to proceed with the trust, there's no fee. We're done. If you do want to proceed, I take down your personal information and your wishes for your trust purpose. I need names and birthdays of all the people that are going to be in your document. So the trustee's name and birthday, that's how I identify people. I do not identify people by addresses. They change. And I don't use social security numbers. I don't want that liability. Right. So, and I would need your grant deed to all the houses that you have. I don't care if you have 10 houses, it's the same fee. It's a flat rate. Okay. But you do pay the recording fee to record the trust transfer deed or the deed that changes it to community property. For investment property, it costs $100 per deed to record. For your personal residence, it's about $30 to record per deed. Okay, so that's your cost, your expense, and then on top of my fee, right? And so I actually take down what your wishes are when I meet with you and then, kind of talk you through it and give you guidance, but I cannot tell you what you want to do. I cannot say, oh, give it all to one child over the other. It's all your money. You can do whatever you want with it. You just tell me what your trust purpose is and I write it up. It's really names and birthdays of your successor trustee, your beneficiaries or your cash gift beneficiaries. And you tell me what your conditions are, I write it up. So it's going to be the will, the executor of your will. It's a catch-all. I just need the person that's going to be your money person, right? The money person is your trustee, the executor of your will, the agent of your power of attorney. And then the healthcare agent, it may be a different person. It may be the same person, the money person, right? You just wear different hats. This is the healthcare hat agent, right? It might be someone that knows more about you than money. I don't know. It's completely your design, and then I put it together, and my fee includes correction. So if you see something you don't like, we correct it right away. It's not a big deal to me. Okay. The grant deed is what gives me information to prepare the trust transfer deed. So I need that, and then I need I don't want your bank accounts. Don't tell me what you have. I don't want, what I do is that I remain your attorney for these documents. I'm not your attorney for a car accident or for something else, okay? Just for these documents. And if you have a question later on, I don't charge to answer questions. You've already paid, okay? And so there is a list of trust assets that a lot of attorneys will say, tell me everything you own because we're going to put it on this list. I think it's absolutely silly because it doesn't count. You have to actually transfer the account to your trust. Your account name needs to say your trust name, right, before it counts, right? And so my advice is every time you do transfer an account to your trust, write it into your schedule of trust assets. I put the house in already, but your bank accounts, write it in Chase Bank account number, and then put an initial and date on it. Yes. If you put the trust of the beneficiary, no. Right? If you transfer the account to the trust, then yes, put it in. A lot of lawyers, there's something called the Hegstag petition. The Hegstag petition means that all the assets under the schedule of trust assets should have been transferred to my trust, and I just didn't do it. All right. So the Hegstag petition tells the judge in probate court, you're still going to probate court. It's kind of silly. Just do the actual transfer. Right? Go down to the bank with the binder and say, hey, transfer. So the Hegstag says that all the bank accounts that I've listed in my schedule of trust assets should be under my trust. All right. The problem with that is that, over time, all those bank accounts change, or you might have done a beneficiary on one of the accounts, and you do a Hegstag with that schedule of trust assets going to probate court. The judge is going to look at it and say, well, where are these accounts? How come you didn't, it just becomes this weird thing, and you still got to go to court. So, you kind of miss the point, right? So what I do is say, hey, just think of the threshold amount. $184,500 is the threshold amount to go to probate court. I cannot touch your account. So you got to do it yourself and transfer accounts to your trust or name a beneficiary. All right. And then you're kind of good with that. All right. If you do transfer it to your trust, just call me and I'll tell you exactly what to do. Transfer the account to your trust. Just write it into the schedule of assets. The schedule of trust assets is not for you. It's for your successor trustee. They need to know what your trust have. All right. And what I normally say is, I'm going to record the trust transfer deed. Once I record it, I'll mail it back to you, put it into the binder. It's for your successor trustee. It's not for you. All right. It's for you. The trust is disregarded. It doesn't even exist. It comes alive when you die. Right. And then your successor trustee is going to open this binder, hopefully sees exactly what's under your trust and what's not under your trust. If you do a whole schedule of trust assets, that's stuff that's not under your trust, it's totally confusing. Right. I mean, it's kind of up to you how you want to do it, but you just need to let your successor trustee know what's under the trust and what's not under the trust, preferably before you die. But, if you die already, then hopefully the binder will tell the successor trustee what to do. Yes. So you're allowed to transfer S-corp stock into your trust. And so your trustee would be the owner of that stock. LLC membership, again, same thing. We do an assignment to your trust if that's what you want to do. A lot of businesses fail. They are successful. You end up selling it. It just becomes a burden sometimes when you transfer it to your trust, but it's up to you. If you want to do it, I do it. It's all included. So it's an LLC membership interest assignment to your trust. If you die, your trustee becomes that owner under your trust, though, fulfilling your trust purpose. It's we can talk about that, but so if your business is going to keep going for many, 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 many years, even after you pass, then yeah, let's just assign the membership interest or the stock to your trust, and then your trustee will continue that. Or sell it. Right. Yes. Again, you get a step up on a death. You don't realize it until you actually sell. And when you sell, you need to report it that the starting point for calculating capital gains is the step up. Right. Yeah, it would be your estate, but I can't, I would defer that question to a tax account. Sorry. It's not really estate planning, but sure. Yes.
I know but if one person pass away, for the avoiding but if the person pass away wants to set up a side on her own share with AB trust. So what do you suggest right now? So still doing AB trust?
Yeah. Remember the default rule between husband and wife, the 50% is locked up. That's the A, and then the surviving spouse is the B. But when we talk about AB, it's really about estate tax, and that's why I don't really, it's silly to talk about it because you're nowhere near the exemption amount. And so I just talk about it as the deceased spouse's share locked up. Okay, you can say it's an AB trust, that's fine. It's really.
So those share belong to the spouse pass away and set aside. So they have to do a whole bunch of things, so the estimate and the house and put aside and also change the title. Belong to.
Yeah, you take the deceased spouse name off. So I tell clients, if you need to refinance the house or sell the house, yeah, you got to take the deceased spouse off. It doesn't change your property tax because you're married. You're not, people grieve. You don't need to do things right away. You have time to do it. I've had cases where the deceased spouse passed away 15 years ago and nothing was done, but it doesn't change the property tax because the surviving spouse is still the owner and they were married. So you're still supposed to report it and you're still supposed to take the name off. You have 9 months, but nobody complies with that. And if there's no reassessment of the property tax, there's no penalty. Right? Because you were husband and wife. Now, if you're not husband and wife, yes, you need to take action. You need to start doing things, especially if your son or your daughter is the one receiving it from your death. Yes. And that's where I would tell your son and daughter to call someone like me. I prepare everything, sign and pay, and then it's done. It's actually based on the trustee's decision too. There's something called trust administration. It's actually statutory. We have to comply with it. But if your trustee is the sole beneficiary as well, there's really no need to give notice to yourself, right? You're supposed to give trust administration notice and a copy of the trust to all the beneficiary. But if there's only one beneficiary, that's the trustee is the beneficiary. It's silly to do it. I don't, if lawyers charge you to like $4,000 or $5,000 to do a trust administration when you're the sole beneficiary, they're crooks. Okay, yes.
Just a comment that the death tax limit is scheduled to sunset in 2026, right?
Yes, but I don't even, it never sunsets. There was a sunset date a while ago and it kept going. So I don't know. I don't think it's going to sunset, but yes, I just don't even think about it because that amount is crazy. Like I've never had a client with that amount. That net worth is that amount. And if you have that net worth, I refer you out to a tax attorney. Because there are many, many strategies to save taxes. There's something called an irrevocable trust. Okay, so let's say your net worth is 28 million, right? You're way over 27 million. For the last remaining million, let's say it's a house. You can put that house in an irrevocable trust. You need to do it 3 years before you pass. And that house value is not counted under your estate. It goes to the same beneficiary under that trust. It's called an irrevocable trust. We don't even go there because you can't take it back. It's irrevocable. right? And if your net worth is that much, there's many strategies to save taxes, to save income taxes. I would just refer you out to a tax attorney who does estate planning.
For those who don't know, the limit will drop in half in 2026.
Right. I doubt it though. People get upset. Yeah. It should always be your spouse first, because they continue the tax deferment unless you have some beef with your spouse. I don't know. It should always be your spouse first. The secondary beneficiary can be the trust, or it could just be your children if the trust gives everything to your children. Yeah.
Okay. Well, I forgot to give the disclaimer. So the views presented today is not the necessarily the views of the FLCC. But
Yeah, go ahead.
Okay. So I said I forgot to do the disclaimer. The views presented today is not necessarily the view of the church here. But I like to say that when people, I'm an attorney, and when people in the church, when people ask me about community property or family law, I always give this response. I only got a C+ in community property in law school. So if you want a C+ answer, you can come to me and take your bets there, or you can see some attorney that's qualified, such as Hong here. So I just want to thank you for coming. So let's give it up. Attorney General.